Welcome back to the Deep Dive. Today, we're cracking open another really key part of the Manual of Patent Examining Procedure, the MPP. We're carrying on with Chapter 400. That's the chapter all about who gets to represent an applicant or owner in front of the USPTO.
Right, the rules of engagement, basically.
Exactly. But let's kick off with maybe a familiar scenario, because this section, it deals with something pretty common, often high pressure.
Okay.
Imagine this. You're a registered patent attorney. Your client just brought you on, like last minute.
Yeah.
And there's a critical examiner interview scheduled for tomorrow.
Uh-oh. Tight deadline.
Yeah, really tight. You feel confident you can sort things out in that hour, but here's the snag. You haven't filed your power of attorney paperwork yet.
The POA isn't in the system.
Exactly. So you have to cancel that crucial interview. That's what we're diving into today. Our whole mission is MPP Section 405. Interviews with patent practitioner, not of record.
And that scenario, that's precisely why this section is so important. It lays out the ground rules for registered practitioners, attorneys or agents, who are ready to jump in but aren't formally on record yet.
Right.
What's really interesting here, I think, is how it draws a line between two quite different kinds of authority.
Different authorities. How so?
Well, the core tension really is this. What gives you just enough authority to, say, file a document? Versus what gives you the authority to actually sit down for a formal binding conversation, the interview itself, because that interview, it changes the prosecution history.
Okay. So it's not just like sending an email versus showing up.
Not at all.
It's more like submitting some background info versus submitting something that could, create estoppel later on.
Precisely. One's procedural housekeeping, the other is substantive negotiation with potential long-term consequences.
Okay, let's unpack that a bit more. So if you are a registered practitioner, attorney, or agent, but you're not formally appointed yet, MPP 405 does give you some leeway, right? You need to be able to do something to keep things moving.
Yes, absolutely. And the starting point for that is 37 CFR 1.34. That's the rule you look at first.
In point 34.
It basically says that a registered practitioner, even if they're not formally listed as the rep of record, well, they are generally allowed to file certain papers, certain documents related to the application.
And that helps keep things efficient, I imagine.
Exactly. It's crucial for efficiency. They can file things like an information disclosure statement, maybe pay some fees, perhaps handle minor clerical responses, that sort of thing.
Okay, so filing under 1.34 gives them just enough power, just enough rope to handle that non-substantive stuff without gumming up the works. A limited representation.
Correct. That act, filing that paper, it works as a very limited and concurrent representation of authority. It's enough for that specific filing.
I sense a but coming.
Yes, here's the crucial gap, procedurally and legally speaking. That limited authority you get from 1.34, it does not automatically give you the right to conduct an interview with the examiner about the substance of the application.
Hold on, why not? I mean, if they're registered with the USPTO, doesn't that show they're qualified, they're trustworthy? Why the extra hurdle, the extra piece of paper, just for a conversation? Why treat the interview so differently?
Because, well, an interview isn't just a chat, you see. It's treated as a substantive, formal legal event. It gets recorded.
Okay.
When you talk to an examiner and you make admissions or you clarify claims or maybe agree on amendment language, that whole conversation creates a binding legal record for the application.
Right, becomes part of the prosecution history.
Exactly. So the USPTO needs absolute certainty that the person in that dialogue can legally bind the applicant. They need proof the representative actually has the authority to, say, negotiate away claim scope or narrow things down, the authority under 1.34. It's just too general, too temporary for something with that kind of weight.
So the examiner, looking at MPP 405, can quite rightly say, look, I see you file that response, thanks for that, but I actually can't discuss the claims with you until you show me specific authorization for this conversation.
Precisely that. You have to demonstrate your authorization using procedures designed specifically for that interview. It ensures that if there's some disagreement down the line, the applicant can't just turn around and say, oh, that person wasn't actually authorized to speak for me then.
Okay, that makes the procedural barrier pretty clear. But, like in our scenario, waiting for a full power of attorney, a POA, signed by the client, well, that might not be practical.
Often isn't.
Especially in patent prosecution, where speed can be everything. So how do you bridge that gap? How do you get that authorization quickly just for the interview to keep the dialogue efficient.
Right. So the USPTO provides two main ways, two procedural tools to grant this temporary limited representative status.
Okay.
The most common way, the one used most often, is submitting the applicant-initiated interview request form. You'll usually hear it called by its number, PTOL 413A.
PTOL 413A. That sounds like the fast pass we talked about earlier. What does it actually do?
Well, you submit it to the examiner before the meeting, and its function is really narrow, very temporary. It lets a registered practitioner, who isn't on record yet, act as the representative only for the limited purpose of conducting that specific interview.
Ah, so it gets around needing the full POA process first.
Exactly. It bypasses that wait time. You're essentially signing off saying, I have authority for this single meeting. It's a representation valid just for that interview.
Is there another option? And maybe, why would someone choose it instead of the 413A?
There is. The rules also allow using the authorization to act in a representative capacity form. That's PTOS B84.
Okay, SB 84.
It achieves pretty much the same basic goal temporary authority for the interview. But often the PTO 413A is preferred because it's explicitly tied just to that interview request. Makes the scope of representation super clear, intentionally temporary. The PTOS B84 might give slightly broader initial capacity perhaps, but it's often used when there are maybe other filings planned soon after. The 413A is really purpose-built for just the interview.
This seems like a huge help for practitioners. Imagine you see a really clear path to getting the patent allowed. If you could just verbally clear up one ambiguous word in the claims.
Right, a quick clarification.
So, by quickly filing that PTOL 413A, you get temporary targeted authority. You have the interview, maybe get that quick resolution, and you've done it without messing up procedure or waiting weeks for the client's formal POA paperwork.
Exactly. It's the system's way of balancing speed with integrity. The paperwork is minimal for the 413A, but the authorization it grants is definitive for that specific meeting. Now, we do need to remember that this faster process, it has its limits, especially when confidentiality is a major concern.
Okay, like what?
Think about unpublished applications. Those files that haven't hit the 18-month publication date yet, the rules there get much tighter, and that's driven by statute, by 35 U.S.C. 122A, which mandates strict confidentiality for unpublished apps.
Right, secrecy is paramount there. So how does that affect our practitioner who's not of record but wants an interview using, say, the PTOL 413A?
It puts pretty strict limits on the examiner. The rule basically says that interviews with an attorney or agent who's not of record regarding an unpublished application will be conducted only based on the materials that practitioner actually provides.
Ah, okay, so the examiner can't just pull up the unpublished file and start discussing everything in it, like internal notes or search results.
Exactly. They're prevented from doing that. They can't discuss the unreleased specification details or internal office actions with that temporary representative. The conversation has to stick to what the practitioner brought to the table.
That makes sense. It maintains that delicate balance you mentioned earlier.
Oh, right.
You allow the necessary communication, maybe based on the claims or prior art the practitioner wants to discuss, but you keep the broader invention details and the internal prosecution strategy confidential before publication. Protects the applicant.
Precisely. It avoids accidental disclosure of sensitive, unpublished information.
Now, MPP 405 also makes a specific point about design patent practice. Why is there a distinction for designs?
Yeah, that's an interesting carve-out. Design patent practice is, well, often inherently simpler and maybe more limited in scope compared to utility patent prosecution.
Less complex negotiations, usually.
Generally, yes. So for design applications only, the rules are relaxed just a bit. Practitioners can rely on that basic 37 CFR 1.34 authority, the one for filing papers specifically, and only for the purpose of conducting interviews related to that design case.
So for designs, 1.34 authority is enough for the interview itself.
For the interview, yes. But, and it's an important, but this is still a narrow exception, if that practitioner wants to do anything else substantive for the design case, like filing amendments, canceling claims, anything beyond just talking in the interview.
Then they still need the formal appointment.
Yes. They still need to be formally appointed as the representative of record. It seems to reflect the office recognizing that design interviews often involve, quick visual clarifications rather than deep, complex legal arguments about claim scope.
Okay, this is where things get maybe a bit more serious. We've got all these rules about who can talk to whom and when and with what piece of paper. What happens if someone tries to cut corners?
Yeah, like tries to skip the PTOL 413A.
Exactly.
Cool.
Or maybe a third party tries to chime in. What's the fallout if someone acts outside that clearly defined, documented scope of their temporary authority?
Well, this is where the MPEP lays down a pretty firm warning. It states clearly that any attempt by, say, a third party or even by a practitioner who knows they don't have the proper authorization for that interaction, if they try to conduct interviews or take other unauthorized actions anyway, that's considered a direct violation of 37 CFR 11.18.
11.18. That sounds familiar. Isn't that part of the ethics rules for practitioners?
It absolutely is. It deals with practitioner conduct before the office. I actually saw a situation once years ago where a practitioner tried to argue their way into an interview after a final rejection. They claimed they had a verbal okay from the client, but the POA hadn't been scanned and filed just yet.
How did that go?
The examiner held firm, cited MPP 405, cited the lack of documented authority. The interview had to be rescheduled. It was a costly delay for the client, all because the procedure wasn't followed. These rules, they really aren't just suggestions.
So violating 11.18, that's not just a procedural slip-up.
Oh, no, definitely not. It elevates it. It moves from being a simple administrative mistake, like maybe getting a filing rejected, into the realm of ethical conduct.
Wow. So the consequences could be pretty severe.
They certainly can be. Unauthorized actions that violate 37 CFR 11.18, that can trigger serious repercussions. We're talking potentially disciplinary proceedings for professional misconduct by the Office of Enrollment and Discipline.
Okay, that really underscores the importance of procedural integrity.
Absolutely. This section isn't just about convenience. It's about maintaining the integrity of the whole patent system. When you use that PTOL 413A, you're not just getting access. You're protecting yourself, your client, and the record by confirming your authority, trying to bypass that documentation. The office sees that as potentially undermining the whole basis of professional representation. #tag outro.
So wrapping this up, what's the big takeaway for you as you navigate patent procedures? I think the crucial point is that authority, especially when talking to an examiner, isn't just general. It's very specific, it's procedural, and it's really carefully defined.
That's right. And the USPTO gives you tools, flexible ones like the PTOL 413A and the PTOSB 84, to make efficient, limited representation possible. But they absolutely expect you to use those tools correctly to prove you're authorized for that formal dialogue.
It's all about having the right key for the right door at the right time.
Couldn't have put it better myself. And speaking of help, we'd really like to extend a special thank you to Mike Shepard. He's the creative director who organized this entire MPP audio series and helped us, make these dense sections a bit more accessible.
Absolutely. Big thanks to Mike. Now, we do have our mandatory inclusion. Just a reminder that this summary of the MPEP was generated using AI tools, including ChatGPT and Notebook LM, and may contain errors or omissions. It is provided for general educational and informational purposes only and is not legal advice or a substitute for formal instruction.
That's right. For authoritative guidance, always consult the official MPEP, a qualified instructor, or a registered patent practitioner. Don't rely just on this.
Okay. And finally, we like to leave you with something to think about.
The provocative thought, perhaps.
Let's try. Considering that just having a conversation with an examiner requires specific temporary paperwork like the PTOL 413A, and that failing to get it could lead to disciplinary action under 37 CFR 11.18.
Which is serious.
It really reveals something, doesn't it? The USPTO seems to view every professional interaction, even just a clarifying chat, not as casual communication, but as a formal, potentially binding exercise of legal authority. What stands out to you about just how high the stakes seem to be for getting the procedure absolutely perfect in patent representation? Something to mull over.